Okay, good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Welvis. I'll be presiding over this case today. I have joining me on the panel Judge Harvey J. from Duval County and Judge John Harris from Brevard County. Just want to make sure that the parties check and make sure that any devices you have that may make noise are silent so it doesn't interrupt the other party in their presentation. And I guess just for the ease of operation, just mute your mic if you're not speaking. That would be great. I will assume, Mr. Palmer, as the appellant, that you would like 5 minutes of rebuttal unless you tell me otherwise. The marshal will adjust the time on the clock based upon your desire. And other than that, Mr. Palmer, you have the floor.
May it please the court. William Palmer of Florida Appeals on behalf of the appellants, and I would like to reserve 5 minutes for rebuttal.
You got
In the time available, I would like to focus on two issues in this case. The first issue is that the final judgment in the dissolution of marriage is incomplete because it does not address all of the assets and liabilities of the parties, and it is inconsistent in that it doesn't carry out the ruling of the trial court to account for all marital assets and liabilities and have an equal distribution thereof. The second issue is that the alleged derivative claims which have been filed should have been dismissed or denied because they were not, in fact, legitimate derivative claims of a company that had been out of business for several months and were, in fact, individual claims. Let me start by a brief overview of the parties and the proceedings below. This case started in April of 2017 as a dissolution of marriage proceeding between the husband, JC, and the wife, she. They had 2 adult children, Tim and Kate, and there was a marital business, Borg, that had been out of business for a number of months and in which the wife had no shareholder interest. 2 years later, in April of 2019, the daughter, Kate, filed an alleged derivative action against the husband, against her brother, Tim, against her brother, Tim's company, FGGI, alleging numerous causes of action, including conversion, theft of trade secrets, conspiracy, etc. The starting point allegation in every one of those counts was the allegation that, quote, JC and Kate verbally agreed to have Borg cease business and to dissolve Borg, end quote. The cases were consolidated for trial. A motion to dismiss the derivative claim as not being a proper derivative claim was denied. And the derivative case was the first one then to be tried. It resulted in a judgment against all of the appellants for approximately $1.2 million, which was calculated as the total value of Tim's company and all the profits from that company, and an additional judgment against the husband for an additional approximately $1 million for monies removed from Borg. The trial court then turned to the dissolution of marriage proceeding, and most importantly, what the trial judge did was rejected a request from the wife for any sort of unequal distribution and held specifically in paragraph 8 of the final judgment, quote, as to the judgment in the derivative action, there is no legal basis to support an award of unequal equitable distribution to either party. Any liabilities associated with the marital business shall be equally borne by the parties, just as all assets accumulated from the business have been split equally.
Mr. Palmer, is there any evidence in the record on appeal that the former wife was a shareholder of Borg?
No evidence whatsoever that the former wife was a shareholder at all. There's some evidence that there were the formalities of corporations were not generally followed with this corporation, but there was no evidence and no finding that the former wife had any shareholder interest in the corporation at all.
And was there any evidence that the former wife was in any way part of the decision-making to cease operations of the business known as Borg?
None as to the former wife, Your Honor. She had been an employee brief at some point, but basically doing some maintenance and that sort of thing, but she had nothing to do with that decision with regard to ending the corporate's existence.
And as far as the evidence, I believe you're disputing the evidence or the level of proof that the former husband and Kate, as has been discussed in the record, were 50-50 partners or shareholders in Borg. Is that correct?
Our clients vehemently denied that she was a 50-50 shareholder, but the trial court found to the contrary. We have not appealed that ruling because since she had put on some evidence that the trial court accepted that she was a 50-50 shareholder, that's not one of our issues for appeal. We felt that was not something that we could argue on appeal because of what the evidence showed.
Thank you.
So once the court made that determination, the problem, which was not cross appealed, the problem is that the equitable distribution schedule that was attached to the final judgment had an entry on it of TBD, or to be determined. And the court failed to then include, this was related to the quote shareholder derivative damages, and the trial court failed to ultimately plug in numbers once they were determined. We raised this error with the trial court in post-trial motions, and the motions were denied. So the final judgment continues to have a TBD in it and doesn't address those issues related to the derivative damages. By not including that in the equitable distribution schedule, the net result was an equalization payment due from the husband to the wife of approximately $153,000. There was a subsequent pre-judgment interest judgment also entered. The two were consolidated together, and they're both before you today for this appeal. So the first issue to address is this issue with regard to the TBD, which continued to be in the final judgment. As I noted, the court ruled that all of the assets and liabilities related to the business were to be deemed marital and to be split equally, but the numbers were never plugged in to this final judgment. So what are the numbers that ought to be plugged in? On the asset side, since the trial court found that the husband was a 50% owner of Borg, then 50% of the two judgments, both the main judgment and the pre-judgment interest judgment, should be plugged in on the asset side. And it could be equally divided between the husband, the former husband, and the former wife. So that wouldn't affect the equalizer payment. On the liability side, the entire amount of the judgment plus the pre-judgment interest, the 2.2 million plus about 600,000 plus on interest, would be put into the husband's column as the named debtor. And if you plug that in, then to carry out the judge's ruling that there should not be an unequal distribution of assets, that would result in now a equalizer payment being due from the wife to the husband of approximately $1.3 million. We've cited in our brief to the Peterson case, which is a case very similar to this, where the court found that if there is an inconsistency between the judgment and the schedule, the remedy is to send it back and direct the trial court to amend the schedule such that it matches up with the rulings made by the trial court. Now, the appellees have raised a number of defenses against this argument, and I'd like to briefly cover some of them, and I think none of them have any merit. The first one is that they claim that the husband waived any argument because they had agreed to the equitable distribution schedule that was provided to the trial judge. But the agreement that they agreed to had that TBD in it. So it was obviously contemplated that the TBD had to be replaced once the numbers were determined in order to carry out the trial judge's ruling about an equal equitable distribution of the assets. The wife then argues that, quote, husband's debt flowing from the judgment and the derivative action could not be added to the equitable distribution schedule, at least without adding a corresponding and offsetting asset. We agree with that completely. That's our position. Both of those need to be placed in there. I mean, we're placed in a situation where we now have a dissolution and we have these various assets and liabilities that haven't been resolved by virtue of that final judgment. So they're sort of left hanging in the wind there. Another argument from the wife is that the entire amount of the judgment should not be included as a marital liability because it is joint and several with Tim and Tim's company, and therefore only some portion of it should count as a marital liability. Now, the wife doesn't cite any case law in support of that proposition, and in fact, the case law is to the contrary. We have cited in the brief the Mondello case, which the wife actually cites for a different purpose in their brief. But that's a case in the fourth DCA, which specifically addressed the issue of whether a joint and several debt should be listed in its entirety as a marital liability or should somehow be broken up because there's more than one judgment debtor. In that case, the fourth specifically held that since every debtor in a joint and several liability judgment is responsible for the entire amount of the judgment, that the entire amount of the judgment should be included as the marital asset. The wife cites the Mondello case, but they do it for the proposition that one of their arguments is, well, the trial court has discretion to make an unequal distribution of marital assets and liability. There's no dispute about that. They obviously do, but that's explicitly what the trial court didn't do in this case. So that can't be a rationale for now leaving it out at this point. The wife also argues that the husband failed to raise this argument prior to entry of the judgment. It's clear throughout the proceedings that this was, in essence, one of the core issues that was involved. You can go all the way back to the joint pre-trial statements back at record 6031, where they specifically outline how to deal or what the issue is with regard to the contingent or the derivative judgment, because the
Mr. Palmer, is there any evidence in this record that the former wife had knowledge or participated in any of the purported tortious conduct in this case?
No, I don't think.
How can she be liable then for the tort? The fruits of that tortious conduct. How can that happen?
Well, I think that can happen just because it is deemed to be a marital liability. The trial court specifically found that all assets and liabilities related to the business were to be considered marital assets and liabilities, and that has not been cross-appealed in this case.
So it would be your client's position that the argument I am proposing that she would not be liable for those damages has been waived by the appellees?
I think that's correct. It was not cross-appealed. And that was clearly one of the core issues being presented to the trial court. If we look even way back at the pretrial statement, when the parties set up what their issues were, wife proposes that husband be solely responsible for any judgment that may be entered against husband in the derivative action. Wife requests an unequal distribution of assets to compensate her for any liability that husband may be responsible for related to the judgment. Husband proposes that any judgment or debts of the company are equally debts and judgment of the marriage to be split equally in the equal distribution.
Going back to the derivative lawsuit, one of the counts is for conversion. And your client is disputing that there was no conversion. So that has been a central issue, or I believe a central issue that was litigated in the derivative lawsuit. So getting back to Judge Jay's question, if there is a finding that there is conversion, which I believe there was a finding that there was conversion, you're saying that liability for that finding of conversion should be shared equally between the former wife and the former husband when you transpose those numbers into the dissolution of marriage case. Is that correct?
Well, I think what I'm saying is that's what the trial judge found by virtue of finding that all assets and liabilities associated with the business would be shared equally, and there wouldn't be an unequal distribution. I think that was an argument the other side made to the trial judge, that there ought to be an unequal distribution, that these things were the responsibility only of the former husband and he should be fully responsible for them. And that was a finding that was specifically rejected by the court when it made its final conclusions in paragraph 8 of the final judgment. Very briefly, if I can move on to the issues with regard to whether these were derivative claims or not, I would note that in each of the claims, the first allegation relates back to this contract that was entered into between JC and Kate. It says JC and Kate verbally agreed to have Borg cease business and to dissolve Borg. And when you look at the elements of this alleged agreement between the parties, it included things like termination of employees, which was already done, payable accounts, that was already done. But the things that were left to be done were distribution of cash to Kate and JC, which is in the nature of a personal claim. With regard to the sale of the equipment, it was specifically alleged that it was, quote, not sold by husband for the benefit of the shareholders of Borg, which sounds like a personal claim, not a derivative claim. And it also deals with payments to the wife, who was not a shareholder. And so that would not be in the nature of a normal derivative claim. A number of the allegations throughout the pleadings talk about things personal to Kate. She was left out of decision-making. She didn't get the value of her shares. She didn't get proceeds from the sale of Borg. She was prevented from selling Borg parts through her own company. Those sound in the nature of personal claims, not derivative claims. The Wojcinski case out of your court, which we've cited in the brief.
And Mr. Palmer, just want to let you know you're into your rebuttal time. So,
okay, thank you. I'll wrap up real quick and say whatever I have left. So I'll finish by noting the Wojcinski case out of this court, where the court recognized a direct claim as opposed to a derivative claim. And they noticed that it occurred because there is a, quote, separate duty owed by the defendants to the individual plaintiff under contractual or statutory mandates. So I would suggest in this case, when they premise their cases first on this contract between Kate and JC as to each and every one of those counts, that's an indication that this should have been pursued as an individual claim, not a derivative claim. And with that, Your Honor, I'll reserve the remainder of my time for rebuttal. Thank you.
okay. Mr. Bogdanoff, you have the floor.
May it please the court, John Bogdanoff for the appellees. The trial court did not err in entering the amended final judgment and in denying the husband's motion to amend the final judgment. The husband stipulated to the equitable distribution schedule, which the court attached to its final judgment. This occurred by way of several exchanges of emails. The court asked specifically that the parties stipulate to a equitable distribution schedule. The parties through emails responded, and the court was informed that the equitable distribution score sheet, schedule that was provided had been stipulated to. The court attached that to its amended final judgment. In the initial brief and in
Is that
the
the one that reflects the TBD?
yes.
So to be determined when?
Well, they stipulated to the entry to this schedule.
Well, the stipulation will be this number will be determined.
No, the stipulation was this schedule will be attached to the final judgment. And if they chose not to include that, that was their choice. Had they insisted on it, then we could have objected. We could have raised an issue with the trial court. We could have brought that to the court's attention. But they didn't.
They did insist on it, didn't they, in a motion for rehearing?
Well, after it had already been entered and after they had already stipulated to its
But isn't
entry.
that the whole purpose of a motion for rehearing, to iron out problems like this? I mean,
Well,
the court on its own and the parties can ask the court to amend the amended final judgment. That's precisely what happened here, was it not?
No, they never asked for relief from the stipulation. They never asserted the stipulation was the product of a mistake. They don't do that on appeal either. Having stipulated to the equitable distribution schedule, filed a motion for rehearing saying, Judge, you made a mistake. You erred in including that as the schedule for equitable distribution. The judge denied their motion. The judge, pretty apparent, hearing all these arguments that this panel's hearing the same arguments today that Judge France heard in connection with the motion for rehearing. Judge France, denied their motion for rehearing because they had stipulated to this. They never asked for relief from the stipulation. They never said it was a mistake, it was an error, or otherwise sought relief from the stipulation. So
I candidly, counsel, I don't understand how you can say they never asked for relief from the stipulation when they asked the court to correct the error. I mean, is that not the same thing? It seems to me a distinction without a difference, but help me understand how that's not asking the court to rectify this.
Well, they had stipulated to the entry of this score sheet, this schedule, and the judge was not going to relieve them of their stipulation because they didn't allege any recognized basis other than, we want you to enter a new amended final judgment. And the judge had already been down this road. The judge had given the parties the opportunity, in fact, had asked the parties to enter into a stipulated equitable distribution schedule. And on rehearing now, they come back and try to, say, well, Judge, you made a mistake. You shouldn't have entered this. The judge was not, open to that because the judge had made every attempt to have this issue resolved before entry. He signed the amended final judgment. And now they come back and raise the same arguments before you, and the judge rejected them. And I think the judge was perfectly within his position to reject those because there were no grounds, asserted for why they should have been given relief from what they had agreed to. So
back to Judge Harris's question, what do you make of TBD? That's to be determined, is it not?
That's apparently why it was included there, but the parties in connection with the stipulated schedule elected not to include anything in there. So that was left blank. And in fact, it was left blank for a good reason, because the debt is not truly a marital debt. This debt was incurred in connection with, at the same time the marriage was dissolved. The judgment dissolves the marriage. The judgment also enters a money judgment against the husband. This is not a debt that, like in the Mondello case, the court talks about it was incurred during the course of the marriage. This debt was incurred at the time the marriage was dissolved. So, the judge had ample additional reasons for concluding that ultimately that this, debt should not be included in the husband's as a liability of the husband. It was not a true marital debt. It was intentional misconduct. The court even found in connection with the some of the counts that the husband had engaged in the trade secrets account, malicious and willful and malicious misappropriation of trade secrets. So we have these intentional torts, and the husband then says at the end of the case, oh, well, it's a debt and she should bear part of that debt. The wife had absolutely no involvement in incurring the debt. There was no benefit to her from any of the corporate activities. This was all done surreptitiously by the husband. And for the
husband,
what
do you make, counsel, of what Mr. Palmer read us? Actually, the second sentence of paragraph 8. What do you make of this language? Any liabilities associated with the marital business shall be equally borne by the parties, just as all assets accumulated from the business have been split equally. What do you take to mean any liabilities?
Any liabilities associated with the marital business shall be equally borne by the parties. This was a liability of the husbands. This was not a liability of the business of Borg. This was a liability personal to the husband. I don't think it falls within that language. I do not
The
believe.
trial court did not specifically identify the the business Borg as solely a company of the husband. That wasn't specifically spelled out. Is that correct?
That the Borg was not.
Right. You're asking for your client to bear no responsibility of the business as it existed as a liability, and yet to have 100% of the benefit of the business as it existed as an asset.
She didn't get 100% of the business. It was divided equally. The assets of the business were divided. Each husband got $701,000, wife got $701,000 of Borg in the equitable distribution. But she should not bear the burden of any of the liability because of the husband's liability. This is a judgment debt against the husband. She should not have to bear any responsibility for that, of those intentional wrongful acts that he committed. It would be totally inequitable. And the judge, in signing the final judgment, entered a judgment that comports with equity and fairness and justice. The fact that the husband stipulated to the equitable distribution score sheet also eliminated the wife's need to cross appeal on the issue of assessment of a portion of the judgment debt against the wife. Having stipulated to it, that issue was off the table. So the wife, at that point, there was no need for her to cross appeal because there was no ruling against her ultimately in connection with the final judgment. So we think that under the facts of this case, and especially since in the brief, they don't even talk, the husband doesn't even talk about this stipulation, the stipulation by email. They completely ignore it because the stipulation is fatal to their contention that somehow the judge erred in entering the equitable distribution schedule that they had agreed to. And in addition, as I said, there are additional reasons why that decision ultimately is correct. And those decisions, those factors work in favor of the wife. There is absolutely no basis for this debt to be apportioned to her when this debt was incurred at the time of dissolution, not during the marriage. It was incurred at the time the marriage was dissolved, and it was incurred as a result of intentional, wrongful, willful, malicious conduct of the husband. There's simply no basis for reversal of the judgment.
Getting back to the stipulation for a second, would it have made a difference? Would it make a difference if it said TBD by the court as opposed to TBD by the parties? Is there any testimony in the record about who was to determine this?
There's no indication as to who was to determine it. However, the equitable distribution schedule was stipulated to the parties as it exists. And so if the parties, if there was some indication that there needed to be a number in there, that's what the judge was asking. Come up with a stipulated equitable distribution schedule. And this is what they came up with, a stipulated equitable distribution schedule. If the husband felt a number needed to be in there, that was his opportunity to insert a number. If the wife felt that that number was wrong, that was her opportunity to object to it. But the husband inserted no number. The husband stipulated to the equitable distribution schedule. And as a result, the judge signed the final judgment and attached the equitable.
And a reasonable inference from that the parties contemplated that the court, they couldn't figure that number out themselves and contemplated that the court would do it. And at the end of the day, isn't it the judge's job to set that amount if the parties don't stipulate?
If they don't, but they did. In this case, they did. If they hadn't, if the husband had said, Judge, I can't stipulate to a judgment here, then the judge would have been required, as you suggest, to ultimately make the decision. But he asked the parties to do that, and the parties did that. And they presented him with a stipulated equitable distribution schedule. And he attached it to his amended final judgment, signed the judgment, and that was the end of the case. And for them to argue that somehow Judge France was in error in doing so, That's unfair, and that's simply wrong. And for the additional reasons that I've given, I think Judge France ultimately his amended final judgment as written ultimately is correct. In addition, there's some contention about the derivative complaint. There was a motion to dismiss the derivative complaint filed below. And the basis of the motion was essentially that this is not really a derivative complaint. It's really a personal grievance that Kate had against Borg. It's a total misread of the second amended derivative complaint. The complaint alleged injury to Borg, damage to Borg. In what way? Borg's assets were converted by the defendants. That's the conversion count, not Kate's assets, Borg's assets. The husband converted $1 million that was in a Borg bank account. That was money in Borg's account. That was one of the allegations. And the husband on appeal doesn't deny. In fact, he admitted below that he took the money. So there's no dispute as to the fact that he took the money and held it for 4 years. That was.
Does it matter, as Mr. Palmer might suggest, that there was never a demand for return of those funds or any of the assets?
Well, absolutely not, because number one, we pointed out in our answer brief the elements of conversion, and demand is not one of them. It's an act of dominion wrongfully asserted over another's property, inconsistent with the other's ownership. But even if a demand was needed, in this case, the husband's position throughout this litigation, even up until the end of trial, was he was 100% owner of Borg. Kate had no interest whatsoever. Even when the trial judge during the trial said, made an interim ruling that Kate was a 50% shareholder, even after that, the husband continued to argue with the judge and say, I don't understand, I'm 100% owner of Borg. The property was retained for 4 years. These assets, the money, the assets of Borg retained for 4 years. They had been transferred from Borg by the husband. They had been transferred to the husband's son, Tim's company, Florida Grinding, and were used in connection with that company for 4 years. Florida Grinding made millions of dollars in revenue off these assets, as the trial court found, hundreds of thousands of dollars in profits off of the use of these assets. And there's absolutely no indication, and in fact, the evidence is just the opposite, that had Kate made a request, that this property would have been returned to Borg. The husband's position was Kate had no interest whatsoever in Borg, and he maintained that position throughout the course of the trial. Tim had made some comment like, well, if at trial, well, if my father had asked me for a return of it, but that's not the issue. The issue is they're claiming that Kate needed to make a demand, and the trial judge had before it ample evidence to conclude that a demand would have been futile and was unnecessary. And so at that issue, I don't think has any basis whatsoever. But the fact of the matter is the complaint, as well as the evidence, showed that not only was there a breach of contract, the contract between Kate and her father, the husband, to wind down the affairs of Borg, which the father breached by, instead of winding down the affairs, he took the money, the $1 million, and kept it. He transferred all of Borg's assets to his son Tim's business. So, that was one of the grounds. This all related to Borg. This was not Kate's personal claim. These were things that were done against the corporation by the defendants. The breach of fiduciary duties, another count. Those were duties owed to Borg. And those duties were breached when the husband, who claimed to be 100% owner of the company, transferred assets, kept money. The trial court subsequently during trial found he was only 50% owner. And as Mr. Palmer correctly notes, they don't challenge that on appeal. They don't challenge the fact that Kate was in fact half owner of Borg. And all these actions that the husband took, the trial court found they were unauthorized because he was not the 100% owner of the corporation that he thought and claimed to be. So the derivative action, the derivative complaint, the second amended complaint, alleged counts against, on behalf of Borg, against the defendants. They were not personal to Kate. Neither was the contract or the oral agreement to wind down the affairs of Borg. That related to the corporation.
Bogdanoff, you've made a lot of comments about the income that the former, the father received from Borg. What was the total income? I guess Borg existed with Kate as the CFO for 7 years. Is that correct?
Approximately, yes. I believe that's pretty.
So what was the income that Kate received as CFO for 7 years?
I don't know exactly, but I can tell you the trial court made a finding that it was minimal. The trial court made a finding that what happened was the father, the husband, had intended and in fact had made Kate 50% shareholder. So she was not receiving compensation regularly from the corporation. And the court found that any compensation she received was minimal. That was another reason why he found her to be a 50% shareholder. Was the judge said that would be absurd to think that Kate left her job, and very good job in California, came here to work for Borg up in Palm Coast and received very minimal payment. That it was very clear that he believed Kate. He found that the husband had no credibility, and that the deal was she would be 50% shareholder. So she received minimal compensation during her years with Borg.
So the best number I could find was she testified, and this was not in any documentation, but to receiving between $4,000 and $10,000 per year. But it was never raised to a level where she reported any of that income. So for 7 years, she worked exclusively for Borg, and the most she ever earned was $10,000. Is that right?
I believe that's correct. And as I said, that's why the trial judge believed that the deal was, rather than pay her significant compensation, the husband, her father, had agreed to make her 50% shareholder. So, and in addition, we would also point out that in the reply brief, for the first time, again, not in the initial brief, but in the reply brief, there's some suggestion that there had to be a demand by Kate upon the board of directors of Borg before she filed her shareholder derivative action. That was not raised in the motion to dismiss, but even so, the reply brief contains a reference to a case called Rappaport, which did not involve the provision of Florida statute 6070742, which is effective January 1, 2020. Kate's second amended complaint was filed February 2020, so after the effective date of this statute. And the statute provides that there doesn't need to be a demand if there are reason or reasons the shareholder did not make the effort to, if there are reasons or reasons, a reason or reasons the shareholder did not make an effort to obtain the desired action from the board. Kate alleged in her in her second amended complaint that it would have been futile again because the husband claimed to be 100% shareholder. He was actively involved in the wrongdoing. And so there was it would have been futile to make a demand upon him. And that's entirely consistent with section 6070742, which was in effect at the time the second amended complaint was filed in February 2020. And unless the court has any additional questions, I would conclude my presentation.
All right. Seeing no other questions, thank you, Mr. Bogdanoff. Mr. Palmer, you may proceed.
Thank you, Your Honor. Just briefly, first of all, with regard to the TBD, two things of note. First of all, the paragraph 8 of the final judgment makes reference to any liabilities associated with the marital business, not any liabilities of the marital business. Opposing counsel argued that this wasn't a liability of the corporation, but that's not what the court ruled. The TBT entry also indicated 50% marital. And so that, I think, disputes the other side's argument that this whole thing was not to be considered as marital. I think it's clear that TBD for shareholder derivative damages was the court was going to determine the amount of the damages as that part of the case, and that those numbers then needed to be plugged in accordingly. Very briefly, with regard to demands on the conversion count, Tim testified that he took this equipment because his father wanted him to keep it for safekeeping, and he would give it back if he'd been asked to do so. The only demand alleged by the wife in the conversion count isn't this demand required for return of property. It was the demand related to bringing a derivative action instead. And the derivative action, the demand for a derivative action did not have a futility exception back before January 1 of 2020. And this lawsuit was filed back in 2019. So at the time she filed the lawsuit, the prerequisite for filing the demand would have been existed, and there was not a futility exception to it. For those reasons, Your Honor, if the court, first we would ask that the court reverse the judgments on the derivative counts on the basis that they were not proper derivative counts, and then insert 0 in the to be determined in the dissolution proceeding. Or if the court does not reverse on the derivative counts, then to insert those numbers both on the asset side and the liability side to conform to the court's ruling that all assets and liabilities should be shared equally. Thank you, Your Honor.
Thank you, counsel. Very well argued. And at this point, we will be adjourned. Thank you. Have a nice day.
Thank you for your time, Judge.
Thank you.